SJC-11849, Commonwealth v. Admilson Resende.
Oh, we're changing order? We're doing Resende before Beal? Doing Resende before Beal. Okay, doesn't matter. Okay, just to be clear, this is Commonwealth versus Resende?
Yes, Your Honor.
Okay, because I think on our schedule we had initially, so just so everybody knows that we should be
Right.
moving to that file as opposed to the Beal file. Because they both involve the same statute at some level, so. Okay. Mr. Levin, you may proceed.
Thank you, Mr. Chief Justice, and may it please the Court, Patrick Levin on behalf of Admilson Resende, who appeals today from the denial of his motion to suppress and from his conviction as an armed career criminal. I'd like to begin with the suppression issue, which I believe chiefly turns on the moment at which the defendant was stopped in a constitutional sense, as many of the cases do. And so the question is simply whether at the moment that he was first approached by police, the circumstances were such that Mr. Resende would have felt free to ignore them and continue about his business.
Before you get too far into that, in your otherwise excellent brief, I did not see any reference to the transcript of the motion hearing. And your argument about clearly erroneous depends on the transcript. It's not in the record. All I see is the judge's findings, which we have to accept unless you
Wait,
show us.
I'm sorry, Your Honor. My references in the brief are exclusively to the motion transcript. Are you saying that Your Honors don't have the transcript?
Maybe I'm mistaken, but I did not see it. All I see in your brief is the judge's findings, which he dictated from the bench.
That's correct. That's all that's included in the brief, but I assume Your Honor should have the transcript before you.
Okay.
Am I incorrect?
We'll check, but I didn't see it.
You can assume either that we have it or that we will get it, so. Because I know you have reference, and
Yes, because the references in the brief are exclusively to the transcript of the motion hearing. There isn't really a trial issue in the case. There's a sentencing issue, and so I cite to the trial transcript insofar as it relates to the sentencing, but the other citations are only to the motion transcript.
So if we can get to back to the issue is, was the judge clearly erroneous?
That's right, Your Honor.
But although it didn't seem as if that was focused on by the defense attorney at the time to indicate that your vision is that the police car basically stopped right in front before he's entering the bar. And I don't know that was that pressed as an argument at the time? Do we have clear testimony, clear enough to say it was clearly erroneous?
I don't recall in terms of the defendant's argument at the hearing. I know there's a motion to reconsider the judge's order, which is in the record appendix, where he does press this claim very clearly. I don't specifically recall his argument at the hearing. But essentially the argument is that the testimony was pretty clear. There's a map in the record. You can see that this bar is on Ames Street, and then there's a parking lot on the corner of Ames and Intervale Streets. The testimony is that the officers drove through the parking lot, turned north onto Intervale Street, at which point Trooper Telford sees the defendant. And then there's some discussion between the state troopers about an officer safety bulletin that Trooper Telford had seen earlier in the week at the Brockton Police Station. They decide to turn around. They make a U-turn on Intervale Street, come back south, at which point both officers testify that the defendant has already made his way across the street and is walking through the parking lot on his way towards the bar. And Telford testifies he then turns left back onto Ames Street, drives past the defendant, and takes another left into the parking lot. You can see in the map that entrance to the parking lot is right next to the bar. And the testimony is that he parked near the entrance of the bar in a close proximity to the defendant. They both get out of the car and approach the defendant immediately. On that testimony, I think it's clear error for the motion judge to find that the troopers waited in the parking lot for the defendant to approach them, which is the finding that he made. And I think a lot turns on this.
But I'm just accepting what you say about parking and getting out immediately and saying, I want to talk to you. But it may be closer, but how do you get from that is itself a seizure?
Well, the significant fact that you're looking at is whether the officers blocked the defendant's path or otherwise controlled
Are you
his...
suggesting that the car parked right in front of the door to the lit?
I'm suggesting that the car parked between the defendant and the door to the lit. And that's supported by the officer's testimony that immediately after he gets out of the car and starts talking to the defendant, the bouncer comes out of the bar to see what's going on. He says, the bouncer and the door to the lit were to my right. Mr. Resende was right to my left. He's standing directly between the defendant and the defendant's intended destination, which is the door of the bar.
So you're saying that the evidence is clear that the car blocked his way?
Exactly.
And I guess that will require a close look to the transcript, but your argument rises and falls on that. I mean, you need that. It seems like you need that to win on this issue.
I think it's fair to say that if Your Honors don't agree with me on that issue, I have a steeper
Have a tougher road to
climb.
hoe. Fair enough.
But
That's Sisyphean, you might say.
well, what I would say is that given that the initial stop Telford testified was based on this officer safety bulletin, the fact that he recognizes the defendant's name after the encounter has begun, and the name, and as it turns out, the defendant isn't the person who's in the bulletin. My argument is that essentially any suspicion that could have arisen from the bulletin at that point should properly have dissipated.
Okay. If I can turn you to the next argument, to the armed career. Do you have any legislative history that would explain why our legislature chose to depart from the language of the federal act?
Your Honor, I didn't make an extensive search for legislative history. This act was passed as part of the Omnibus Gun Control Act in 1998, and as far as I'm aware, there was no specific legislative history about this particular provision. It's a 2,000-page bill, and I'm not sure if anyone focused on this.
When was because the federal ACCA was also amended around then, or?
My recollection is that the federal ACC was amended in 1988.
Oh, 88. I knew there was an 8 in there. Okay, so
It was 10 years later.
Yes, and
And-
the federal statute had been authoritatively interpreted by the time
So
of,
the separate occasions language had been there for 10 years.
yes, for at least 10 years, I believe is the case. And I cite multiple federal cases that stand for this proposition that what the federal statute means is as long as there are factually distinct crimes, they count separately.
How
But
did
obviously, the Massachusetts legislature departs from this language, and the federal language has a clear focus on the factual circumstances of the offense. The language is offenses committed on occasions separate from each other. And so you can see that the verb committed is clearly can only modify offense, and there's a clear focus on the factual scenario. The Massachusetts statute requires convictions for the various offenses, convictions arising from separate incidences. And my contention is that this is at the least ambiguous as to whether the incidences that it refers to speak to the factual scenario underlying the charges, or the process underlying the convictions, because I think that the word arising is more naturally read to modify the word conviction as opposed to offense.
So basically, as I understand your argument about the structure of it being a graduated set of provisions, is that they have to be separated by opportunities for reform. So the only way that would happen is not only, they would have to be separate actual convictions.
No, would arrests do?
Or what is it that would give somebody the opportunity to reform?
Well, I would say that it's the interaction with the criminal justice system that is really significant.
So if he had been arrested over this 1 month period of time, 6 different times, what do you say then?
In that case, I would say, I would still argue that there hasn't been a significant opportunity to reform over that period.
So how much do you need? Do you need a conviction, or you need something shy of a conviction? Or when does he get the opportunity to reform?
Well,
it's not after being arrested. Okay, that failed, that sale failed, that sale failed. You
Your
got
Honor,
caught again, you got caught again.
Your Honor, many courts hold that the second offense in a graduated statute like this has to have been committed after the conviction and punishment for the first offense.
But do they have language like ours?
The language in those statutes, each court has a slightly different,
But
each
well,
state.
let me say,
But
maybe
the
it's-
language is not the same, no.
But is it, I guess this is what I really mean, is it language that provides, that's reading a lot in. Are those statutes that the other states are dealing with reading a lot in like that? Or do they have something that's guiding them more to the?
Some of the cases are reading quite a bit into the Alaska case in particular. I believe the language in that statute just said, for the first offense, the punishment shall apply for the first offense, and then for a second offense, the maximum punishment doubled, and for a third or subsequent offense, the maximum punishment doubled again, I believe was the situation in the Alaska statute. And the court says essentially that the point of these kinds of graduated statutes is that we impute more culpability to someone who has been punished without being reformed, who's not subject either to rehabilitation or to specific deterrence based on his record of prior punishment without stopping.
That's what Pennsylvania kind of uses that language, right?
Yes, Alaska, Pennsylvania, Kentucky, I believe, Washington State. There are a number of these cases that many of them actually date back to the early 20th century.
So as a practical matter, though, that would require like a lot of time between the events.
I think that's fair to say.
So if somebody's in a crime spree, gets arrested each time, for some reason gets bailed and goes out and does it again and again, your view is that's not a good predicate offense.
Well, Your Honor, what I'd say is that a spree is not a career. And the point of these statutes is to focus on individuals who are shown to be dangerous and unreceptive to being reformed or deterred over a long period of time.
So the fact that it would require a period of time, a long period of time, is actually part of what you think is
Is part
implicit
of
in the statutory scheme.
implicit in the scheme and the legislative intent behind this graduated structure.
What, so if you had, instead of, as in this case, you've got a series of individual drug sales, you had 2 completely different crimes. You've got on one a burglary, and then 3 days later there's a possession of a gun, or just something very different, and they really don't have any connection, but the Commonwealth brings them at the same time. That would also fit within your scheme because there just isn't much time? Even though they're
Yes.
just completely different
That would also fit within the thrust of my argument about the structure of the statute and the legislative intent. Obviously, I have made a secondary argument in the brief, and I also would note that I think that there's a certain logic to the way that the federal sentencing guidelines work, which I also cite in the brief.
I wanted to ask you that. Is there, I saw that, and that's very interesting. Did they ever articulate how they managed to get to that, given the language of the federal ACC?
Well, the guidelines here don't deal with the federal ACC. The
Federal Sentencing Commission guidelines don't?
not the guidelines that I'm citing to.
Oh.
These are about a separate sentencing enhancement under the guidelines for career offenders.
Prior offenses.
Right. And so the Federal Armed Career Criminal Act, that specific language would supersede this more general guideline about career offenses. Yeah. And unless there are further questions,
All right,
I see my
thank you.
time is up. Thank you.
May it please the court, Carolyn Burbine for the Commonwealth. I just want to address the first issue, I'm afraid I'm going to forget. This court obviously will accept the judge's findings of fact absent clear error, and it's our position there was no clear error. And I would point out that as far as the testimony goes, on cross-examination, defense counsel did not push this idea now presented on appeal that the car blocked the defendant's path. The questions that were asked of Trooper Telford were, by defense counsel, were, is it fair to say that he parked near the entrance that you parked near the entrance of the lit? Yes. Is it fair to say you parked in close proximity to the defendant and the two females? Yes. And when you exited the vehicle, could you clearly be ID'd as a police officer? And he said yes, with the badge and the gun at my waistband. So there was no.
What page is that at, please?
I cited it in my brief, I believe, but on cross, it would be volume 1, which was the motion to suppress hearing, pages 62 to 63.
Thank you.
And on direct, Trooper Telford testified that he saw the defendant walking across the lit parking lot towards the front door. He took a route that got him into the parking lot. He stopped the car and got up. He walked up to the defendant, and that's on page 30 of the same transcript. And I would point out that I did read defense counsel's argument at the motion to suppress hearing, and he never argued that there was that the trooper had deliberately parked his car and blocked his path. So I would argue that given the testimony of the troopers and the judge's explicit statement that he did not credit any of Mr. Junta, the bouncer's testimony, and he credited all of the troopers' testimony, that there was no clear error in his findings. As far as the armed career criminal statute, it's our position that the defendant is incorrect, that there's no ambiguity in the statute. It clearly says, whoever having been previously convicted of 3 dangerous drug offenses arising from separate incidences, and that would be a reference to the separate criminal acts,
Yeah,
not
Why wouldn't
each
they just
conviction.
use the same language as in the federal statute if that's what they meant?
Well, I don't think
They
that
do
they're...
that, this is one of the, if you superimpose our statute over the federal statute, this is one of the few pieces of it that's different.
Well, I think that they used it as a model, but they didn't necessarily, you can use a statute as a model, but change the language to make it perhaps more clear,
I know,
if you
but
think that's more clear.
they use the same language to describe the offenses that would trigger the statute, but they didn't here, so.
It's a word choice, but I 100% disagree that it's not consistent with it. It's just that they chose different language. Maybe they didn't like the language. Maybe they didn't think it was clear. I don't have any indication. I don't have any legislative history that
But my point
discusses
is,
that, but-
when they do choose different language, why should we just accept your argument that this is what they meant to follow what the federal statute says? Why doesn't that suggest that we need to look at what separate incidences mean? It is ambiguous. It's
well,
not clear.
Then this is why I argued that when the definition of terminology does not appear in the statute, then you look at the plain meaning, and then you look at what sources would have been available to the legislature, and the dictionary definition that I set out was an occurrence or an act is an incidence. And then I would say that U.S. v. Letterlow supports my argument. That's an interpretation of the federal statute, and it notes that the federal statute uses the terminology committed on occasions different from one another. And I would argue that, you know, that just like ours, focuses on when the crimes occurred. And indeed, in Letterlow, the court said, committed on occasions different from one another shows, committed on occasions different from one another, and then they say an occasion is a particular occurrence. Now, that's right in line with ours. And that supports my argument that when our legislature said arising out of separate incidences, they meant, as Letterlow says, the federal statute means arising out of separate occurrences.
But would
So I
you
would-
agree with counsel's point? I hadn't thought of this. I think he said that that language in the federal statute, separate occasion, had been interpreted for maybe a decade before the legislature adopted our version of the ACC. So if that's the case, and if it's been interpreted to mean any prosecution, any conviction, wouldn't the legislature's choice of different language suggest that they did not intend our statute to follow the federal statute on that point?
I'm not sure that I agree that the federal statute, they don't go by each conviction, they go by each separate occurrence,
No,
just
I
like
understand.
I'm arguing we do.
I understand.
So I would say the choice of, I don't think our legislature's has to use the words exactly as a federal statute does when they're using it as a model, if they feel that different wording would be clearer, or they just, I think that's just a word choice, but I don't think it's ambiguous.
If a
And
defendant committed a string of B&Es on, say, 5 B&Es on 5 different dates, consecutive days, and uses the same MO, oftentimes, or in fact most often, I would suspect that they're tried at one trial, because the evidence, even if they were severed prior, they could be used as prior bad act evidence in each trial. But they're usually tried together. In that event, that they're all tried together, could the Commonwealth treat the defendant as an armed career criminal?
If those are separate,
If they're tried
violent
together?
crimes, there has to be violent crimes, I believe.
Well, okay.
But
Armed assault in a dwelling.
I believe so, because that's 6 separate incidences. I mean, the defense would argue common scheme, but I would argue, you've got 6 separate dates, 6 different victims, 6 different
Even at the same
locations.
trial?
Well, this was one plea that had them all.
This was a plea, but
Okay, even in one plea?
I would say I would have to, yes, because that's what happened here. We had 6 separate drug deals on 6 separate dates, all involving cocaine.
Right, but
and-
he's being sentenced on a subsequent offense, right? So we're talking, in other words, statute says whoever having been previously convicted.
The convictions preceded the
Right,
act.
so the convictions couldn't be all at the same time.
Right.
You have to be
Well,
previously convicted, and that's when you are subject to the Armed Career Criminal Act. Correct? Yes, that is correct,
Right.
right? You couldn't, in one
sorry, I guess I don't
proceeding,
understand
be
the
saying,
question.
well, you committed 5 crimes, and we're charging you with 1, 2, 3, 4, 5, and the last one was later than the others, so now we're also charging you with armed career criminal. It couldn't be in the same proceeding.
I understand.
So if they severed out, if they tried them separately?
Well, that's the thing. I mean, if they tried him, I think I'm getting lost. I
Okay.
apologize.
I guess why, I'm trying to figure out, I mean, the state statute differs from the federal in 2 ways. It differs in terms of this choice of language, but it differs in that the federal statute has only one escalation. You go from nothing to 15 years. Here, there are 3 steps step one is, I think, what, 3 years? And that's step one. Step two is 10 years, and step three is 15 years.
Right.
Doesn't that suggest a view of escalating deterrence? That the legislature wanted to basically say, listen, you did it this time, if you do it again, it's going to be higher. If you do it a third time, it's going to be even higher. Isn't that what the legislature intended?
Well, you have, but you also have to, but I still don't see how arising from separate incidences can be anything but, I mean, my point, if they wanted to say, it would have been very easy for them to just change the language had they wanted to and say, having previously been convicted of 3 serious drug offenses arising out of separate indictments. That's not what
Right,
they
well, of
did.
course, it would have been easy for them if they want, I mean, by your standard, it would have been easier to keep the federal language, which was perfectly clear and had been understood. So we're trying to figure out
understand.
why they changed, and I'm trying to figure out why it would, I mean,
Well,
would the legislature intend this result? I mean, the result here of an individual involved in 3 separate drug deals, and that moves him, he doesn't go to step 1, he doesn't go to step 2, he goes straight to step 3 just because there were 3 undercover buys, as opposed to you only charge him with 1 undercover buy. I mean, is that what the legislature intended?
I believe so, because this is a public safety concern. I mean, you have.
So somebody is more, the legislature thought a drug dealer is more dangerous because he engaged in 3 separate sales in whatever the year was.
7?
In 2007, and that makes him more dangerous than, because he's charged with 3 separate buys than 1 buy, and therefore that means that he has to go all the way, skip step 1, skip step 2, go to step 3?
Well, the public, I mean, the danger to the public is that he has been convicted of, he's pled guilty to these crimes in this scenario. And now he's on the street, 10 years later, he's still committing crimes, and he has a loaded gun in his pocket.
I
That's a
understand, I
public
understand that.
safety
The question is,
concern.
why would the legislature want him to go to step 3 as opposed to just step 1?
Because now he's so dangerous. He's just he's a dangerous
Is he
criminal.
any more dangerous? I mean, I guess the trouble is, he had steps 5 drug sales in the course of a month. He doesn't get charged after each one. He gets charged ultimately with all 5 together, right? That's what happened. He gets convicted. So is he more dangerous than if he'd had 5? How do you say that's more dangerous than if there'd just been 1 drug and he had 1 conviction in that month?
Well, it's the legislature. I just still think you have to go back to the plain meaning of the statute, and the plain meaning of the statute goes as to the offenses. It does not say to the number of convictions. If the legislature had wanted it to say the number of convictions, it would have said so. And I don't think there's any way to escape that. And whether there's an agreement as to whether that's reasonable or not, that's up to the legislature. That's the wording that they chose.
Well, we understand that, but the question is, can you give us any legislative intent which makes your interpretation make sense?
I just believe public safety. You can't have armed criminals. He's been convicted, he's had his chance to reform. He served his Plymouth House sentence, and yet he's out there still committing crimes,
Right,
and
well,
now he has a loaded gun in his
I
pocket.
understand that, but the question is, why would that not mean he would go to step 1? You're arguing that the legislature intended that he go to step 3.
Because he's constantly selling drugs. This wasn't like a one-kind time thing. He didn't just go out once, make a mistake, sell drugs. He did this progressively over a period
Okay, so
of
if
days.
if
He's
they
a
had,
career.
so if, I mean, how much was he selling, by the way? What are the quantities that was involved in these
I
sales?
don't believe that was in the
Okay, but I mean, it sounds, I mean,
transcript. It
so
was
if,
hand-to-hand.
hand to hand. So if they had found a stash of 200 kilograms of drugs in his house, that would be 1, and they charged him with possession with intent for 200 kilograms of cocaine. That would be 1 conviction, and he would, the next time, get only 3 year based on these cases. He'd only be step 1. But because he managed to do hand-to-hand buys, three hand-to-hand buys, he's now, the legislature wanted him to move to step 3. That's how we should infer what the legislative intent was here?
Well, I think that would that be trafficking?
He'll be trafficking the first
I still would say
time.
that the legislature, they're looking at career criminals, repeat offenders, people who are not going to reform. They could have done a three strikes kind of thing where, you get a chance to reform, you get a chance to reform, you get a chance to reform, okay, finally. And they, in a way, have done that with the, but this guy, he had a chance to reform, and he's right back out there doing it again. And I think that's the kind of person, they see that he is a repeat offender. He's not going to stop. And now he's carrying a gun on the street, and it's loaded, ready to be fired. And I don't think that that's contrary to the legislature's intent.
Is it relevant at all that the Commonwealth brought all of these cases as a single prosecution rather than different prosecutions, which clearly it could have done? They all
No, I don't
happen
think
on
anything should be read into that. I don't think that's any kind of
Why
indication
not?
of.
Because it certainly
That's
suggests that this is one piece of action. This is a single course of conduct.
I disagree. What it is, you have the same police officers, the same city, you have the same types of crimes, you have the same people involved, and just in terms of, why would you have 6 trials if you can, it's just judicial economy and concerns.
Why
That's our
would you? Why
discretion.
Why would you?
But that doesn't.
Because you obviously think that they're linked because they're together. They would survive a joinder challenge.
I'm not sure that I'd say that. It's because it's more, you have to get the police officers in to testify. We have to consider those aspects too. I don't think it's a sign that we think it was a common scheme. It's just, he was arrested after an undercover investigation.
How else
and
would you
he
bring
got-
these together if they weren't a common scheme?
Well, I don't think they're a common scheme in that they're not, in that they're all one incident. I'm not going to.
I didn't say that.
Oh, okay, I'm
They-
sorry.
they're-
I thought. But
By bringing them together, it suggests that it's a common scheme. It's one course of conduct.
Well, it's the same defendant doing the same types of crimes in the same area during a 2-week period, but I don't want to do anything that would make it seem that I'm conceding that this was any kind of a common scheme or one incident under the statute. I definitely want to point out this was 6 separate incidents, 6 separate dates.
But
6 separate
does when your office charges 6 crimes together, should we not understand that you expect them to be tried together?
No, we do. I'm sorry if I didn't state that clearly.
Okay,
I'm
so
sorry.
we can infer that the prosecutive decision to charge them together infers a prosecutive intent to try them together.
Yes, I would assume.
Okay.
Did the court have any further questions?
Thank you.
Thank you.
We'll take our morning break.